Case files 24-02561.
93 days, right? Is that what you recommend?
Yeah.
That's what you recommend, but you were cool with it. You said no probation. And hey, Andrew. Hey, Andrew. No. Andrew. It's not everybody's in the same socioeconomic class as you are. It was 400 for the tether just to buy it, and it was 300 for a month just to get it.
The last thing I want to do is put you in jail because you're causing an upset to the court.
I agree. Preston, I agree with that. What up, man?
I need you to relax.
Otherwise, I'm cool.
You're here on a review. Yeah,
I'm
here is
Mr.
Finley. All right, Mr. Finley, you have to stop. You have to stop. The review to get you back on the right track.
Right, but here's another thing, and here's another thing, and when we need people to, and you gave me time, that would be like giving someone time for a parking violation. It don't make sense, Andrew. You smart, man.
That's not how this works. I'm gonna give you a chance to relax.
Right. Just stand here and let's do the review.
Mr. Young.
I'm still here, good. And you can read it, all the statutes you want. If it doesn't make sense, it doesn't make sense, Andrew.
Mr. Finley, I have to hold you in direct contempt for continuing to interrupt the court. You're sentenced to a day in jail.
Buckle up, guys. Today we're diving into one wild courtroom clash. It kicks off with Mr. Krusel flooding the judge with bizarre motions and pseudo-legal nonsense. You can feel the tension as Judge Oakley tries to cut through the chaos and bring order, but Krusel is relentless, pushing his sovereign rhetoric to new extremes. This is where you instantly know this is not going to be an ordinary hearing.
Good morning, Your Honor. Elizabeth Smith, P63010, appearing on behalf of Midland.
Plaintiff, please state your name for the record.
Rachel Langoni.
Your volume is a little low.
Okay. Is that any better?
That's better. Okay, so today was the date that was scheduled for a motion for summary disposition that was filed by Midland. They're asking for the court to strike, excuse me, the defendant's answer and dismiss the counterclaim, saying that the counterclaim doesn't seek relief that the court could grant.
She is seeking dismissal of the claims against her and asking for an award of $3,744. It does not go into any detail about anything my client would have done wrong. So there's really no basis on which to grant any sort of relief as to the counterclaim. As for our motion for summary disposition, reviewing the defendant's pleadings filed, the crux of the matter is she doesn't believe that she owes anything to Midland because the original creditor was a different entity. So it was a Children's Place credit card held through Comenity Bank. The account was used. We attached about a year and a half worth of billing statements to our motion showing use, purchases and payments on the subject account. In December of 2021, the account was charged off and sold to Midland. Also, as part of our documents is a letter sent by Comenity to Ms. Langoni explaining that the account with Comenity has been charged off. It was purchased by Midland Credit Management. Any further communications and or payments were to be made with Midland Credit Management. Ms. Langoni did in fact contact Midland and set up a payment plan. The payment plan was ultimately defaulted with only 1 or 2 payments having been applied to the account. So there's just really no issue left to resolve. Midland owns the account. The balance due and owing, there's no dispute as to that. There's no dispute that Ms. Langoni had the original card. The only issue is her belief that she doesn't have to pay Midland. And again, based on the proofs provided by Midland, and the fact that there was in fact a payment plan set up with Midland, I'll point to the fact that Midland does in fact own the account, is permitted to collect on same. And so we're asking that Your Honor, please dismiss the counterclaim for the reasons previously stated, and then also grant summary disposition on Midland's claim, as there really is no underlying.
Things heat up fast. Mr. Cruzel's antics escalate as he stubbornly refuses to acknowledge the court's authority. Watch as Judge Oakley's patience wears thin, her tone shifts, her questions get sharper. Cruzel, unfazed, doubles down with more baffling legal jargon. The courtroom vibe turns from tense to combustibly, can almost see the contempt ruling coming.
The thing that she told me that I could do was to ask you to amend my response. As far as what she sent, I still, when we were here the last time and I met with counsel in a separate room, I still maintain that I would like to see the contract. Whether that's, I mean, especially between myself and Comenity, to see that they were legally able to sell the debt. Because if I could go to trial, I would show that the chances that the Comenity was paid for the debt. And I want to be able to show that. It's very different, because if I were to go to court with Comenity, that would have to go through a federal court. It's very different than saying that I owed it to Midland.
Let me get some clarity here. You're not disputing that you had a Children's Place account, correct?
Correct.
You're disputing, and you're not disputing that there was a balance of $643.63?
No, I'm not disputing that.
Okay, your dispute is that you have paid that $643.63?
It was paid when I opened the account.
It was paid by who?
The process, and this is why I wanted to go to trial, because there's so much.
Up again because here, Cruzel crosses the line. He interrupts repeatedly, talks over the judge, and ignores clear instructions. Judge Oakley isn't having it. She warns him, gives him chances, but the disrespect is nonstop. You can feel the entire room holding its breath, waiting to see if she dropped the hammer. And folks, she does not disappoint.
Argument that credit cards aren't real money, and somehow by opening a credit card, Comenity is really doing some other sort of banking thing, and it's not really money that has to be paid back. You have to let her give her response, because she's not actually drafted a motion or Sure.
responsive motion to you. And then I'll let you respond to what she's saying, but she's got to have an opportunity to make her statements as to what she believes her defense is.
Sure.
So you're saying you didn't pay, you charged $643.63 on the Children's Place card, but you didn't pay for it?
I did pay on it at the time, because I didn't realize what had happened. And when this all started, when I started questioning what was going on, I had called Comenity.
What do you mean what was going on? I don't know what that means.
When I was trying to understand the legalities of a contract and how the banking system works, I was just studying this on my own. And so I had called Comenity a couple times, spoke to two different people, and all I did was I wanted the original contract so that I could learn the legal terms, how it works, the process. And when they kept telling me that they didn't have this contract, that's when I started asking more questions and learning that how important contract law is, and the fact that it's somehow magically disappeared. I don't understand why the most important legally binding contract would have just magically disappeared. So I started asking a lot of questions, and what I'm basing it off of is off of federal regulations, federal codes, the UCC 3. It's not what the attorney just made it out to be, but it is a lot to explain, and I'm still learning. But I do want to maintain my right to defend myself against.
That your right to defend yourself starts with the summary disposition. You don't just get to skip over that portion. If there is a motion for summary disposition, they're saying that you don't have a valid defense, that you have not presented an issue of genuine dispute. You need to now plead to me something that makes me believe that there is an issue of genuine fact that needs to be resolved by either a jury or a trier of fact. And you've not yet provided me that. That's why it was important for you to respond in writing to their motion. I'm giving you an opportunity now to respond verbally, but I need to hear some information that would allow me to understand your mindset and why you believe that you can open a credit card and then charge a balance and then not have to pay the balance.
Right, and that's.
So answer that.
All right, guys. Now, it's official. Judge Oakley holds Mr. Krusel in contempt of court. But instead of backing down, he continues with his wild claims and defiance. The judge's sharp responses are gold-measured but firm. This part really shows the clash between courtroom reality and sovereign fantasy. And the way Judge Oakley handles it, it's masterclass.
Borrow money and not pay it back. That's honestly,
Okay, so
that's not what it's about.
I don't mean to cut you off, but I'm trying to follow. So your dispute is that the past due debt was charged off. I'm not following what the dispute is.
I feel like I need to, I obviously I didn't go to law school, so understanding this process is not easy for me. And if I lose the case, it's going to be because of a procedural issue and my own fault, not because I'm wrong, though. I've learned way too much about the bank's process at this point. But well, I just have to maintain that there's no contract.
I would disagree with that because what you've said so far was that you opened a credit card, that you used that credit card to purchase some things, and then you didn't pay the credit card. And I'm trying to understand, but you said that the credit card, it was paid, and I'm trying to figure out how was it paid if you didn't pay it?
It's the banking process when I provide my social security number and did not fully understand what I was signing and what I was signing over.
Okay, so because you signed a contract for a credit card and you didn't fully understand, you think that that's a defense?
Well, see, that's the tricky thing is my defense would be different with Comenity versus Midland. So anytime
we're not talking about that. We're not talking about what hypothetically your defense would be with Comenity. This is Midland Credit Management versus Rachel Lamco.
So I'm maintaining that they don't have there's no contract to base any of the allegations in the papers that Midland has submitted. It's all based off of if there was a contract, and there is no contract.
There's no contract, you mean, between you and Midland Credit Union?
Asterisk, things get even crazier here, guys. Krusel, now in contempt, still tries to argue jurisdiction and spout conspiracy-laden nonsense. Judge Oakley moves to finalize the contempt charge, laying out crystal clear reasoning. Krusel's tone shifts, he's still defiant, but the consequences are sinking in. The tension is high, the stakes are